Does it work? Okay. Thank you very much for coming. We organized this Human Rights and Security Forum together with International Law and Human Rights Unit and School of Law here. So we would like to welcome here Judge Silvis, but I'm not introducing this event at all. I will pass this honor to the head of our department, Professor Amandine. You're supposed to speak here.
Okay. Thank you very much, and good evening, everybody. Thank you very much for coming. The honor falls on me to introduce the event, Judge Silvis and Professor de Londras this evening. So the lecture is going to be on terrorism and human rights, and I happened to be in Paris last week, and a few months after the November attacks, I was walking in Place de la République, one of the symbols of Paris life, not only because this is where we start all our strikes, and we have quite a few, but also because this is where, when the country is hit, this is where people will give their messages of solidarity and so on and so forth, and show some caring moments for the rest of society. And this is exactly what happened. Even months after these attacks, there was a certain solemnity around the Place de la République, and you couldn't help feeling moved and quite emotional, with moments of sadness, moments of anger, moments of sheer incomprehension when you saw all these pictures of victims and the silence around the place, which is one of the most buzzing places of Paris, if you know Paris. And I think as lawyers, we have a duty to reflect rationally around all these emotions and reflect on these emotions and what we should be doing and what the societal response should be about these attacks and all the many others that we've encountered over the last years, over the centuries. So I'm really delighted that tonight we're going to address some of the very, very difficult and complex and questions around terrorism. To what extent is a state under a positive obligation to protect its citizens against terrorism? Would it be viable to fulfill such an obligation without violating other fundamental rights and freedoms? And are the ordinary requirements for a fair trial compatible with national security when suspects of terrorism stand on trial? So I'm really delighted that we have two experts in the field, and I'm very honored to introduce Judge Silvis, who is and has been since 2012 a judge in the European Court of Human Rights in Strasbourg. Now, before being elected at the court, he has had a very distinguished career in the Dutch judiciary, being Advocate General at the Dutch Supreme Court, after having served as a judge and vice president of the Court of Appeal in The Hague. I saw in your longer biography that you also had a PhD from the University of Utrecht and had been a lecturer in Utrecht, a master's, so I misread. But you have some experience of academia and experiences academia, and it's a great honor for us to welcome you here tonight. Thank you very much indeed for your time and for coming to share your expertise with us. We very much look forward to your talk. And I will introduce as well Professor de Londras, who happens to be an ex-colleague and is a friend of mine from the University of Durham, but he's also a friend of many colleagues here. Constantine, who is organizing this event, Rumi, who has written a PhD under Fiona's supervision, and many others, I'm sure. So Fiona is a professor of global legal studies at the University of Birmingham, but she's also adjunct faculty at the University of South Wales in Australia and at University College Dublin. And she's held a range of visiting positions in this country, Oxford, and elsewhere in the world. And it's a real pleasure to welcome her here. She has a wealth of experience in the area of human rights and counter-terrorism more specifically. And she's published very extensively in this field. I'll limit myself to a few books that she's written. The War on Terror, Detention in the War on Terror, published in 2011, Critical Debates on Counter-Terrorism, Judicial Review, CUP 2014, and the Impact, Legitimacy and Effectiveness of EU Counter-Terrorism. And having worked with Fiona a bit, not much, but a bit before, she's a powerhouse of energy, so it's a real pleasure to welcome her here back in Liverpool this evening. So the floor is yours. The format is that you're going to present and deliver your lecture. Fiona, you're the discussant, and I think you've both accepted to take questions after your presentation. So once again, thank you ever so much for joining us this evening, and the floor is yours. Thank you.
Well, thank you very much for being here tonight, and thank you very much for the invitation and the introduction. It's quite a topic, human rights and terrorism. And of course, there is an abundance of case law of the Court of Human Rights dealing with terrorism in the context of human rights. But before entering into the particulars of this case law, it's good to remind us where the human rights idea comes from after World War II. The world had faced atrocities as a consequence of state terror, and human rights formulated in the Universal Declaration of Human Rights were formulated in a way to prevent the state infringing upon the human rights of individuals. And the Convention on Human Rights, the European Convention, which was very much inspired by the Universal Declaration. And the drafters of this convention wanted a system with a commission, with a court in the end, in order to have an effective institution dealing with human rights, not just to have a text, but also an institution effectively dealing with human rights. And the idea was that if we have in Europe a democratic system in the different countries, and if all these countries would respect human rights, that would safeguard peace and stability in Europe. That was the basic idea behind human rights. And since human rights were formulated as guarantees against infringement, the stress was very much, of course, on the negative side of human rights. But after the tragic shooting which led to the death of Mr. Osman and the wounding of his son, the court noted that the first sentence of Article 2, which is about the right to life, enjoins the state not only to refrain from the intentional and unlawful taking of life, but also to take appropriate steps to safeguard the lives of those within its jurisdiction. Here you see the positive obligation of the state to safeguard the lives of those within its jurisdiction. Now, for the court, bearing in mind the difficulties of policing in modern societies and the unpredictability of human conduct and the operational choices which must be made in terms of priorities and resources, such an obligation must be interpreted in a way which does not pose impossible or disproportionate burden on the authorities, you can imagine. And in the opinion of the court, where there is an allegation that the authorities have violated the positive obligation to protect the life in the context of their duty to prevent and suppress offences against the person, it must be established, and this is called the so-called Bosman Test, it must be established to its satisfaction that the authorities knew or ought to have known at the time of the existence of real and immediate risk to the life of an identified individual or individuals from the criminal acts of a third party, and that they failed to take measures within the scope of their powers, which, judged reasonably, might have expected to avoid that risk. There are many definitions of terrorism. For instance, if you read the case of Sadi versus Italy, and I know some of the students here present have heard about this case. This is about an expulsion case of a terrorist suspect from Italy to Tunisia. Terrorists are described as persons who channel their fundamentalist faith into violent action. That's one of the definitions you find in that judgment. But in the same judgment, there's a referral to a report of Human Rights Watch on Tunisia, noting that the 2003 anti-terrorism law gave a very broad definition of terrorism, which could be used to prosecute persons merely for exercising their right to political dissent. So it's quite different from the first definition. Terrorism in the UK Terrorism Act differs from the concept underlying the Convention on the Prevention of Terrorism of the Council of Europe. The Convention on the Prevention of Terrorism contains no general definition of terrorism. And if you look at the explanatory report, you read that the drafting process deliberately avoided making a general definition, because the purpose was not to draft a comprehensive convention on terrorism, but an instrument of much more limited scope for the prevention of terrorist acts. It uses the concept of terrorist offense. In its definition, it's an offense of public provocation, which means those offenses contained in the international counter-terrorism conventions. If you look at the United Kingdom definition of terrorism, you see three essential issues. The first is violence or threat of violence. The second is the designation to influence the government, the intention of change, fundamental change, and the use or threat is made for the purpose of advancing political, religious, or ideological cause. That's the United Kingdom definition of terror, the points of the definition of the United Kingdom Terrorism Act. The Court of Human Rights has no definition of its own. It can operate with different concepts of terrorism in relation to the domestic concepts from which cases come to the court. The reality behind the concepts, that's what matters. And labeling a situation as terrorism, of course, not automatically establishes state intervention as legitimate. It could be observed that while concepts of terrorism differ a lot, counter-terrorism is a much more unified concept when it is approached from the perspective of human rights. It's important, if you deal with the subject we're dealing here this evening, it's important to know that the Convention of Human Rights has a derogation clause. It is possible, on the basis of Article 15 of the Convention, for a state to notify the Secretary General of the Council of Europe, saying that there's an emergency situation in the state, threatening the life of the state, which makes it possible to derogate from the human rights and freedoms normally the state should secure. It's important to state that this derogation clause has only relevance in relation to the so-called relative rights, not to the absolute rights. Relative rights concern the right to liberty, the right to freedom of speech, family life, private life. Absolute rights, like the right to life, the right not to be tortured, these absolute rights cannot be derogated from under the Convention. It's very important to make this distinction between relative rights and absolute rights. You may know that at the moment in France, there is an emergency situation. État d'urgence in France. I think it's the 6th time after the World War France made use of the possibility to call the emergency, state of emergency, on the basis of its national law. This state of emergency was also notified to the Secretary General of the Council of Europe, and the state of emergency was prolonged already for 2 times now. And the Secretary General of the Council of Europe has expressed concern about this prolonging, because it is a very serious step to limit also the relative rights of the Convention. On the other hand, it is imaginable that in certain situations there is a state of emergency, making it necessary to take certain steps. That's at least the position under the Convention. And also you can find examples in the case law. Secretary General of the Council of Europe wrote to the French President, "I sincerely hope that the current plans for constitutional and criminal law reforms will secure the essential balance to which you are personally committed." It is diplomatic language, but it is critical at the same time. Counterterrorism poses enormous problems for a country. You can all imagine. I'll give you 3 examples in the case law of our court concerning the absolute rights. And then I turn to the relative rights. First, the absolute right of the right to life. Some of you will know the Mccann case. Beth on the Rock. It was illustrated and reconstructed in a documentary which was broadcasted on Thames television in 1988. Facts may be sketched as follows. Early 1980, United Kingdom, Spanish and Gibraltar authorities concluded that the IRA were planning a terrorist attack on Gibraltar. And to prevent this attack, the Commissioner of Police of Gibraltar was assisted by military and security officers. According to the Commissioner, the target was highly probably the band and guard of the 1st Battalion of the Royal Anglian Regiment during a ceremonial changing of the guards at the Inns Hall, 8 March 1988. There were indications that the method of the terrorist attack would be strike with a bomb. An IRA unit of 3 persons was assumed to carry out the attack. Among them, an expert bomb maker. The Commissioner's plan was for an arrest to be carried out once all the members of the terrorist unit were present and identified, and when they had parked a car with which they intended to leave, which they intended to leave before to detonate it. Now, 4 soldiers were to arrest the IRA persons. The instructions included the possibility of the need to shoot. The 3 suspects were followed closely by soldiers, and just before the intended arrest, soldiers thought the suspects were about to detonate the bombs by pressing a button, and they were gunned down. I won't go into the details of this operation. It appeared afterwards that there had been no risk of detonating bombs because there were no explosives in the car. Elsewhere in Spain, very far away, a car with explosives was found that could be related to the killed IRA suspects. An inquest took place in Gibraltar, and the jury concluded that there had been lawful killing of terrorists. The applicants, representatives of the estates of the deceased, brought the case to Strasbourg. And the court examined the case. And the court had, of course, had to bear in mind that the information that the United Kingdom authorities received that there would be a terrorist attack in Gibraltar placed them for a fundamental dilemma. On the one hand, they were required to have regard to the duty to protect lives of the people, including the military personnel, and on the other, to have the minimum resort to the use of lethal force against those suspected of posing this threat in the light of the obligations flowing from the Convention. The court's case law concerning terrorism cases has been constructed around this balancing of different interests at stake. On the one hand, the protection of the fundamental rights of the terrorist or suspected terrorists, and on the other, the interests of national security, public order, and the protection of the rights of others. In this specific case, the court was not persuaded that the killing of the 3 terrorists constituted the use of force which was no more than absolutely necessary in defense of persons from unlawful violence within the meaning of Article 2. The second case I want to present to you is the siege of the Dubravka theater. It's the case of Vinoganov and others versus Russia. In 2002, a group of armed terrorists belonging to the Chechen separatist movement took some 900 people hostage in the Moscow Dubravka theater. And the applicants were either hostages or relatives of those hostages who died in the course of the subsequent rescue operation. The applicants that came to the court. The hostages were held at gunpoint and the theater was immediately booby-trapped. So there was a very dangerous situation. The terrorists demanded immediate withdrawal of Russian troops from the Chechen Republic. And negotiations were conducted and several hostages in the meantime were shot dead. The authorities then created a crisis cell under the command of the Federal Security Service, and they made a rescue operation. In the morning of 26th of October, that's 4 days after the action of the terrorists had started, Russian security forces pumped an unknown gas in the theater, a narcotic gas, in the main auditorium through the ventilation system. And a few minutes later, almost all the terrorists had lost consciousness under the influence of gas. And the special squad stormed in the building and killed most of the terrorists. The hostages were then evacuated from the building and transported to hospitals in ambulances or city buses. However, 125 hostages died on the spot or during transportation. A criminal investigation was opened, but on the domestic level, there was no reason for prosecution found. The court, in this case, afterwards, you can imagine there's quite a difference whether you are, as chief of a security unit, responsible for what to do in a situation of a theater with terrorists booby-trapped who killed already a number of people. What should you do? And then you do a thing, you pump gas into the theater, you try to rescue as many people as you can, and then there's the court in Strasbourg telling you what you should have done. You can imagine that is sometimes hard to take, but it's important to evaluate such situations afterwards, not that you know better or that you are superior to those who did it, but in order to learn from the experience and to do better next time. The use of force was accepted by the court. The use of gas, we still don't know exactly what kind of gas was used, was accepted by the court. But then the planning and the implementation of the rescue operation, and there the court said this was not sufficiently prepared. The rescue plan had been flawed in many respects. There appeared to have been no centralized coordination of various services involved. There were no instructions on how information about the victims and their condition could be exchanged. One result of this was that some victims received multiple doses of antidote. It was unclear what order of priorities had been set for the medics. No medical assistance was provided during the mass transportation of victims on city buses, and there was no clear plan for the distribution of the victims to various hospitals, with significant numbers arriving at the same hospital at the same time. The court therefore concluded that the rescue operation had been not sufficiently prepared and that the state failed to fulfill its positive obligations. The third example, very fresh of course, the Armani da Silva versus the United Kingdom, delivered 30 March of this year. This is about the criminal conviction of the police force, and then the question arises, should the individual police officer not be prosecuted following a fatal shooting incident? Jean-Charles de Menezes was shot dead in error by special firearms officers while on the underground in London in the wake of a series of bombs on the city's transport network in July 2005. After his death, extensive investigation was conducted and detailed investigations report were published. The Office of the Commissioner of the Police was found guilty for criminal charges under the health and safety legislation. But the applicant, a cousin of the late Mr. de Menezes, the victim, complained about the failure not to prosecute any individual officers. The judgment of our court, I think, is interesting because you find in this judgment a comprehensive outline of the procedural investigative requirements in cases of using lethal force by state agents. And the judgment is also interesting for another aspect, and that is clarifying what the court meant in the Mccann case, I dealt with it here before, by an honest belief that the use of force was justified, which is perceived for good reasons to be valid at the time, which subsequently turns out to be mistaken. And our court has chosen to take the subjective position. It is not the detached observer that is important in order to establish the individual responsibility, but it is the perspective of the person with his honest and genuine belief. And in that regard, the court considered whether the perspective of that person was subjectively reasonable, whether there were subjectively spoken good reasons for it. And the court accepted that the prosecution did not choose to prosecute him. The test whether there was sufficient evidence to provide a realistic prospect of conviction was accepted by our court. So no violation was found in this respect. Absolute right, the right to life, is essential. Another absolute right is the right not to be ill-treated. Now, it's a well-documented fact that in the course of counter-terrorist action, people may be at risk of ill treatment. This may be so when security officers or military men are in hot pursuit of suspected terrorists, like we have seen. And another interesting example concerns the widely debated methods of interrogation in a situation of which you may call a ticking bomb. It's a well-known dilemma in ethics. What methods of interrogation are allowed when it is likely that the individual being interrogated is supposed to have knowledge about an upcoming event of terrorism? Last weekend, we heard on the radio that one of the arrested suspects was said to deny giving information about a rucksack with explosives somewhere in Brussels. This sounds like a situation of a possible so-called ticking bomb. There might be an acute risk for citizens. Now, from the perspective of the Convention of Human Rights, the answer to the acceptable methods of interrogation is relatively simple. Torture or inhuman and degrading treatment are absolutely forbidden, also in situations of emergency. The Supreme Court of Israel has dealt with this subject more than once, and it left open the possibility to create a legislative basis for the use of moderate force during interrogations. At the same time, it considered the possibility of an ex post facto necessity defense as to the methods of interrogation used cannot ex ante legitimize the use of force during interrogations. In a classic case, the interstate case of Ireland versus the United Kingdom, known as the Who Did Man case, our court concluded in 1978 that 5 techniques of interrogation, sort of sensory dissociation technique, as applied in combination, undoubtedly amounted to inhuman and degrading treatment, although the object was to extract confessions, naming of others, and information, and although they were used systematically and they did not occasion, according to our court, to the suffering of particular intensity and cruelty implied by the word torture, as so understood. Here the court differed from the Commission that unanimously had expressed the opinion that the combined use of the 5 techniques in cases before it not only constituted inhuman and degrading treatment, but also torture. The opinion had not been contested by the United Kingdom before the court. But now a request to revise the classic judgment is currently pending before the court after the opening of the British Archives has given rise to suggestions that the government would have withheld relevant information to the court, according to the applicant state, Ireland. And our court has communicated this case. So at a later stage, our court will have to come back to this case. And you can find the questions communicated on UDoc. Whether there is inhuman or degrading treatment or torture is important, but both are absolutely forbidden. So in this respect, there's no difference. But in relation to the use as evidence or the consequences for the trial in which this plays a role, there is a relevant distinction. Our court has also prohibited extradition of requested suspects if it was likely that torture evidence might be used against the requested person in a criminal trial. Othman versus the UK of Abu Qatada is another name. Extradition to Jordan was prohibited by our court after he obtained guarantees from Jordan. He was extradited to Jordan, and if I'm not wrong, he was acquitted in the process in Jordan, but I'm not absolutely sure about that. A third category of cases I would like to mention in this respect are the so-called rendition cases. These are cases where our court had to deal with applications which suggested that there might be specific cooperation of states with the CIA in capturing terrorist suspects and secretly rendering them into CIA detention. One of these persons was Mr. El-Masri, a German citizen from Lebanese origin. At a certain moment, he left Germany on a tourist visit to Skopje. And at the border of Macedonia, the former Yugoslav Republic of Macedonia, he was arrested and then he was rendered to the CIA. And he was very badly treated until they found out that he was not the suspected terrorist, but he was a person who simply had the same name as the person they thought it might be. He had been taken to a CIA-run facility called the Salt Pit, that is a brick factory north of the Kabul business district that was used by the CIA for detention and interrogation of high-level terrorist suspects. He was further ill-treated for over 4 months, and in May 2004, that is quite some time after he had been arrested, he was taken blindfolded and handcuffed by plane to Albania, and subsequently he got back to Germany. He was 18 kilo less of weight than when he had left Germany. We've had already a number of these kind of rendition cases, and if you see the Senate Committee's report from the United States 2014, when the documentation was declassified by the Intelligence Commission, you find all of these cases that our court has dealt with back in that report, and it confirms the factual basis on which our court took the decisions. Relative rights. The right not to be deprived of one's liberty is a relative right, as I said. The first case ever dealt with by our court, the case of Lawless versus Ireland, is such a case about preventive detention of suspects in an alleged state of emergency following terrorist threats. Lawless was first arrested with 3 other men in 1956 in a disused barn, and the police discovered there a Thompson machine gun, 6 army rifles, 6 sporting guns, a revolver, automatic pistol, and 400 magazines, etc. And he was held detained. But at a certain moment, there was a period of detention when there had been no intention anymore to bring him to court. The only intention was to keep him detained, and there was no other basis. But the derogation, which had been notified to our court, and in this case our court had accepted the exceptional circumstances to state that this detention during a period of July till December 1957 was founded on the right of derogation. In the case of A and others versus the United Kingdom, there is a detention of individuals with the view to expel them. But at the same time, the expulsion was prohibited because the risk of ill treatment in the place where this person was to be sent to. This is a dilemma that happens more often. The state wants to expel a person on, in principally, acceptable grounds, but it shows that if the person would be expelled to the country of destiny, he would be ill-treated, tortured, perhaps shot dead. And then it is impossible under the convention to expel him to that country. Following the terrorist attacks of 11 September 2001 on the United States, the British government considered the United Kingdom also to be under threat of a number of foreign nationals present in the country who were providing support network for extremist Islamist terrorist operations linked to Al-Qaeda. And certain of these individuals could not be deported for the reason of the risk of ill treatment. And the government considered it necessary to create an extended power permitting detention where the Secretary of State reasonably believed that the presence in the United Kingdom was a risk to national security. And then, since the government thought this might be inconsistent with the convention, they issued a derogation notice under Article 15. And in this specific case, already in Britain, the Lords indicated that the reasoning on the basis of this measure was not sound, because it based the action on whether these were foreign persons or not. And the reasoning was not directly and simply based on the real dangerousness. And therefore, it was discriminatory in relation to persons of another nationality in relation to persons of British nationality who might have been quite as dangerous at the very same time. And our court followed the reasoning. The Supreme Court, you would now say, could take a position, but this was only a position in law without consequences on the specific case, and therefore also in this respect our court had a say about it. It is important to note, however, that our court accepted that the public emergency threatening the life of the nation can be accepted in a situation as there was in the United Kingdom after 9/11 attacks in the United States. A state could not be required to wait for a disaster to strike before to take measures to deal with it. But in this specific case, the derogating measures were not strictly required, according to our court, basing itself also on an analysis which was done domestically. I skip a bit and indicate another pending case which concerns access to lawyer. The pending case is Ibrahim and others versus the United Kingdom. I already mentioned the bomb attacks in 2005 in the underground, when 52 people were killed as a result of suicide bombings in London. Further bombs were detonated on the London public transport system, but on this occasion failed to explode. And perpetrators fled the scene, and the first three were arrested immediately, but refused legal assistance for a period between 4 and 8 hours to enable the police to conduct safety interviews. And the fourth applicant was not suspected of having detonated bombs. First he was heard as a witness, and he incriminated himself, and later on he became a suspect as well, but he was not immediately dealt with as a suspect at the moment. The police already thought that he had incriminated himself. The court will deal with these cases. These are pending before the Grand Chamber, and the question is of such delayed access of a lawyer in such a situation in order to perform safety interviews, and in the other case delaying the status of being a suspect, is acceptable or not. Privacy and security. There is a recent case, which is not really a terrorist case, but it is important because it holds many of the aspects of case law when it concerns privacy and security. And this is obviously relevant in situations where there is thought to be a risk of terrorism. And the case is Roman Zakharov. It's a case of December 2015, and our court intended to clarify in that case the scope of the safeguards which must accompany surveillance of communication from the standpoint of Article 8 of the Convention, which holds the protection of private life, to put it shortly. And the applicant, Mr. Zakharov, was an editor actively involved to promote independence of regional mass media, freedom of speech and respect of journalist rights, and he provided legal support, including through litigation, to journalists. And he brought judicial proceedings against mobile network operators, and he complained about interference with his rights of privacy. There are several problems involved in cases like this. One of the problems is that if you come to the court, you'll have to make clear to the court that you are a victim. Now, the surveillance of communication gives this complexity that you may have the idea that there is such surveillance, but how to prove it? If you don't get notified, it's very hard to know. And this is the dilemma for our court. Our court first has to accept that a person is a victim in order to be able to deal with the case. But since it is also obvious that it could very well be that persons are under surveillance but cannot prove it, that our court is forced to go into the abstract law, while the intention of our court is to deal with real cases and not with abstract law. And in the Zakharov case, you find a sort of a solution for this dilemma. Our court looks at the scope of the legislation, whether it's reasonable that an applicant can be affected by such legislation, looks at the availability of remedies, and the court will adjust the degree of scrutiny depending on the effectiveness of the remedies. Now, in a case where in a domestic situation there is a rigidum of remedies, where persons are notified, our court will step back and say, okay, well done. It's not for us to step in such a situation. But if the legislation offers huge possibilities to make surveillance of individuals possible and not to notify these individuals, our court sees a lower threshold to step in, and then looks at the aspects like the scope of application of secret surveillance measures, the duration of secret surveillance measures, the procedures for storing and destroying intercepted data, the way the authorization of interception takes place, the supervision of the whole framework. These are the aspects you can find in detail in the Roman Zakharov case, which is very important. There are some other cases pending. There's a Big Brother watch and others for the United Kingdom case, communicated in 2014, which will bring some more insight in secret surveillance and the like matters. Last issue I just want to mention, I won't go into it, is the UN listing of persons. You may know You may appear on a United Nations list that your property should be frozen, that you may not enter a certain country. And this listing takes place under Chapter 7 of the UN Charter. And it is very difficult to find in the UN context a remedy against such listing. And then there is the debate about the supremacy between the courts, between the Human Rights Court and the UN, and also in the CADI judgments of the Court of Justice of the European Union, you find the same debate about the supremacy. There is a pending case, Al-Dolimi and Montata Management Incorporation versus Switzerland, which is pending, where you find exactly this issue. It's related to Panama, which is interesting at the moment, because the money was situated through Panama. I come to a concluding remark. In the Convention, the possible need for states to derogate from peacetime standards of human rights protection is recognized. And it's difficult to assess what circumstances may legitimize the use of the derogation clause in the Convention and how long this may last. Where terrorists seek to destroy democratic values and fundamental rights and freedoms, we should be on guard, also to prevent that counterterrorism would not do that job for them. Thank you.
Thank you.
Yes, I got it.
Thank you. Sorry. All right, let me start by adding my thanks to those of Judge Silvis, to Constantine, but also to all of you for coming this evening, and to Professor Gard and the school for supporting the International Law and Human Rights Unit, which in turn has supported this event. I'm also very conscious that I have a couple of advantages over Judge Silvis in this context. The first is I don't have to speak for as long as you did. The second is I already know what you said. And the third is that I'm not speaking within the confines of a judicial role. So I can say perhaps some more critical or provocative things, provocative is a better term perhaps, than the nature of the judicial role allows one to say, either in a lecture or indeed from the bench. And in some ways I want to start more or less where you ended, with this idea that the architecture of human rights protection, both at European and international levels, recognizes that there are some situations in which a state will experience a form of security crisis or a form of insecurity that goes beyond the quotidian or the normal insecurity with which we expect our states to grapple on a daily basis. It is, of course, the case that insecurity is not an exceptional state of affairs. We experience insecurity every day. We lock our doors, we put on our house alarms, we try not to walk somewhere quiet in the dark at night, etc., and etc. And we expect the state to protect us in some ways from that insecurity, and to do so within the normal confines of human rights law and of the pact that we have made between the governed and the governors. But so too do we recognize that sometimes we are faced with a form of insecurity that is exceptional or extraordinary in some way, and that either the nature of the bargain that we have struck between the governed and the governors, or the way in which that bargain is operationalized through law and other procedures, will shift for the duration of dealing with that exceptional or extraordinary kind of insecurity. And it is in some ways that pragmatism or that Faustian pact that lies at the heart of human rights law, which allows for things like derogations, which recognizes things like exceptionalism, and which makes the question of this relationship between terrorism and human rights, or security and human rights, so tricky and so knotty, both for courts and governments, and indeed for academics. And so we've already had an excellent engagement with the case law from the Strasbourg court, many of the core cases relating to this. And so in the short period of time available to me, what I want to do is to sort of set out what we might expect a subsidiary regional human rights court like the European Court of Human Rights to do in the context of exceptional insecurity like terrorism, and then to think about or offer some provocations as to whether or not the European Court of Human Rights has tended to perform in the way that we might expect by reference to those expectations. But to start, I suppose it is important to recognize a couple of things about how states act in the face of a perceived terrorist risk, or this form of extraordinary insecurity. The first thing that I think it is important to say is that the vast majority of states, the vast majority of times when they're countering terrorism, I believe act with sincerity and in what they believe to be the public good. And that is the case both in terms of the laws that they are creating and implementing, and in terms of the operations, like in Gibraltar, for example, that states and state forces undertake. It is true that states will sometimes succumb to the reflexes of hyper-securitization, that sometimes public demand for action will result in overreaching and overstretching by the state, that the impact of these measures are felt disproportionately by people who are perceived as other, who are alienated, and who are treated in a manner that is unacceptable from the perspective of, at the very least, a sense of citizenship and a sense of parity of esteem between all those who reside in a state when the state is responding to terrorism. But I'm not sure that those realities necessarily mean that we live in malevolent or dystopian states. I think they mean that terrorism and insecurity is a difficult problem, that the people or the polity have an expectation that that positive obligation that we have of the state to protect us from insecurity, which you started your lecture with, would be given effect to in a manner that keeps us entirely safe, even though somewhere in our minds and in the reality of living in a state of government, we know that we cannot litigate out or mitigate all risk, that we cannot create a situation of absolute security if we are to have any kind of rights-based or democratic polity. And so it is a very difficult situation that states are trying to deal with. And in doing so, we see them introduce all kinds of measures, some of which have already been mentioned. Everything from sort of quotidian burden sharing between the state and private entities. So you mentioned sanctions lists. Sanctions lists will only work if banks are on board with them, for example, if airlines are on board with no-fly lists. So we share out the burden of insecurity from the state to a number of other organizations like telecommunications companies on a regular basis. We also tend to make adjustments to criminal justice systems and procedures, both by introducing new offenses in many cases. We have in this jurisdiction seen the introduction of very remote offenses since 1999, the Terrorism Act in 2000, and of course since 2005. We also make adjustments to what we might ordinarily expect by means of due process, whether that is expecting that we would know the case and the evidence against us, having access to a lawyer of our choice and a normal and privileged lawyer-client relationship, or having access to a jury by means of example. So we make adjustments of those kinds very often. in the last 15 years, we have seen a very significant digital turn in counterterrorism, which culminates in things like surveillance, mass surveillance, and targeted surveillance, but also in things like sentiment analysis online and the engagement with online communities in order to try to counter so-called radical narratives. And of course, we see also the very extreme things that we are familiar with as being deeply problematic: extraordinary rendition, detention without charge, torture, and so-called coercive interrogation. So there's a wide range of things that states have a tendency to engage in when they are faced by a form of insecurity that they consider to be exceptional or extraordinary, so that the ordinary or the normal apparatus of the state and the rules within it, which it operates, might not be sufficient to fulfill the obligation to keep us safe in the way that the state perceives it ought to, and the polity might demand that it does. In those kinds of situations, it is not perhaps unexpected or surprising that states might, as I said earlier, overreach, that states might do things that go beyond where we consider the appropriate limitations of state power to lie. It is also not unconceivable that where that happens, domestic organs of the state might not properly identify that overstepping, so that Parliament might not push back and refuse to legislate in the way that the government might have asked, or so that domestic courts might not find a violation of human rights or the Constitution, depending on the system. Because, of course, one of the challenges for the domestic system in these kinds of situations is precisely the geographic, the temporal, and the political proximity between the organs of state and the perceived insecurity, so that it is difficult to find a cognitive distance, right, between the insecurity we perceive and the parties we rely on to provide oversight for the state. And so in those kinds of situations, the role of supranational, subsidiary regional human rights courts, like the European Court of Human Rights, I think is particularly important. And I think we might say that we would expect or need or hope that those kinds of courts would do a couple of particular things for us. One thing we might expect or hope those kinds of courts to do is to challenge dichotomies or perceptions that underwrite a lot of the counterterrorism laws and operations that are actually undertaken by the state. So the idea, for example, which is popular abroad, as the saying goes, that security and liberty are in some form of irreconcilable tension, that one must give in favor of the other. And indeed, that where one gives liberty, another benefits security. What Andrew Ashworth calls the assumption of a hydraulic relationship between security and liberty that cannot be established as an empirical matter. We might expect the supranational court would at least cause some pause for thought about an assumption of that kind, about the idea of exceptionalist narratives. Both the idea, perhaps, that terrorism as a risk is an exceptional form of violence that must be, or an exceptional form of insecurity that cannot be responded to within the normal apparatus and architecture of the state, and more recently, the claim that contemporary terrorism is exceptionally exceptional, so that the counterterrorism we had before is insufficient to respond to the terrorism we have today. So we might hope that supranational institutions like the European Court of Human Rights would again of course not get rid of any kind of narrative like that, but at least probe it and cause it to be established or substantiated in some way. We might expect that absolute rights would remain absolute through the intervention of these supranational courts. We know that the category of absolute rights under the Convention is small. We've talked about Articles 2 and 3. But we might expect that the court will ensure that states cannot erode the absoluteness of those protections, no matter how dangerous the state says the situation is. And we might, and I think fundamentally we would hope that a court of that nature would insist on the effective separation between that which is properly classified as exceptional and that which is properly classified as normal. In other words, that the court would ensure that exceptional measures introduced to counter an apparently exceptional security threat would be quarantined to situations of that kind through the effective application of a provision like Article 15, and not through tinkering with, or in some cases radically undermining, ordinary expectations of criminal due process and the criminal justice system. And this is, I concede, a heavy weight of expectation for a supranational court to try in some ways to help us to maintain basic tenets of constitutionalism that we struggle to maintain when we are frightened and at risk and responding to something that seems almost impossible to manage, right, with the best will in the world, such as a threat from terrorism. And so if we think about those kinds of expectations, and if we agree, which we may not, that they are fairly placed upon a court of the nature of the European Court of Human Rights, we might ask ourselves how the court has performed against those kinds of expectations. And I think that in doing that, we must fairly start from a point where we recognize that the legal system within which the court is dealing is one that is built on the pragmatic recognition that sometimes states can do things we would not ordinarily permit them to do, right? So it is built, it has within it this recognition of exceptionalism, which we hope will be maintained within the context of Article 15. And so as a result of that, when Article 15 is invoked, as it not always is, but sometimes is, we might expect that if the court is convinced that there really is a war or public emergency threatening the life of the nation so as to permit derogation, that then it would be pragmatic in terms of what it permits states to do or not do by reference to the convention. What we have seen over a long course of jurisprudence from the court, starting indeed with Lawless and Ireland and the United Kingdom, is generally a very permissive approach by the court to that antecedent question of whether or not the public emergency in question really exists. So a very deferential or accepting approach to the claims of the nation state, including those kinds of dichotomous claims about exceptionalism and ordinariness, and particular claims about the relationship between security and rights that underpin Article 15 claims in the first place. And it is important, I think, that we note that in the case of A against the United Kingdom, which the judge referred to, as well as finding, following on and talking about detention under the Anti-Terrorism, Crime and Security Act of 2003, the court also accepted that temporariness was not required to evoke a situation of exceptionalism. In other words, you would not have to establish that the exceptional insecurity in question was temporary in order to be able to invoke Article 15. And that raises some serious questions about whether or not we really can quarantine those exceptional measures to exceptional cases, if exceptionalism can be, fairly long-standing or long-lasting. I think that it is true that the court has maintained real procedural rigor in respect of Article 2 and Article 3, and has worked very hard to maintain the absoluteness, particularly of Article 3. We already mentioned the Sadi case, which is particularly significant when one remembers that very soon after the attacks of 2001, the then Prime Minister, Tony Blair, said it was now clear that the Chahal standard would have to be revised. This is the standard that the case in which the court initially found that you could not take into account the risk a person was thought to pose to the state in which they were when determining whether or not to deport them, if you accepted that they were at a real risk in the country to which they would be deported. In Saudi and Italy, not only Italy but also the UK as an intervener, were explicitly trying to undermine or get the court to move away from the Chahal standard, and it refused to do so. And I think that is extremely significant in maintaining the absoluteness of Article 3. There is at least an argument which I put to you, although I'm not sure I agree with it, that the way in which the court deals with Article 2 cases in the context of terrorism suggests that what that article is now doing is, rather than really protecting the right to life per se, is establishing how states can kill someone without violating the right to life. In other words, creating very high procedural expectations so that even if there is a deprivation of life at the end of it, there may not be a violation of Article 2. It is difficult in some ways to see how else a court can actually approach that, but the critique exists. So I throw it out there, as I said, by means of provocation, and of course the part of the potency of that provocation or critique is that if, as Judge Silva said, one of the things that the court can do is to engage in an ex post facto analysis from a legal perspective of how well or how carefully security operations were carried out as a matter of fact, then engaging in a heavily proceduralized way of thinking about Article 2 might be thought to be problematic. So that's a critique that one can think about. I think it is true that the court continues to leave, as I said, a very significant margin of appreciation to states, not only in being highly deferential to states' assessment of whether or not the situational risk that they are dealing with is such as to be exceptional, requiring security measures, but also in relation to whether or not the measures then introduced are necessary and are only go as far as is strictly required by the exigencies of the situation. I think I would not be the first to suggest that the European Court of Human Rights does not always apply the rigor that we might hope for in the context of asking the necessity question. Is this measure necessary? And by reference to what will we expect a state to establish that necessity? That is perhaps entirely understandable when we remember that this is a court, in other words, deals with law. It's not a security oversight body, and also is a subsidiary court. It doesn't have a huge amount of choice about it, but there is nevertheless a question there. And so while overall, and I'll finish up here so that there's time for questions and answers, while overall it is true that the court has maintained the absoluteness of a number of protections, it has absolutely ensured that rights talk and thinking about rights has to be maintained regardless of how exceptional or how exceptionally exceptional perceived insecurity happens to be. And while it is also true that the court has been an extremely important agent for international accountability, for example, in the rendition cases, which you spoke about, there are critiques that can be levied of how the court has approached the questions of the relationship between terrorism and human rights. Has it really challenged that notion of a dichotomy between security and liberty? Has it forced states to substantiate their claims of exceptionalism and of necessity? Has it quarantined exceptional measures to truly exceptional situations? And perhaps more fairly to the court, is it in fact set up in a way that would enable it to do so, even if it decided that it was inclined to? So I'll leave it at that so that there is time for discussion.
Thank you very much. Thank you very much, Beth. I don't think that I need a microphone for a couple of reasons. First, that it doesn't really matter what I say. Yeah. And second, well, I can still make inappropriate jokes and not being labeled a threat to the United Kingdom. There is a microphone somewhere in the room. Professor Londras and Judge Silvis have agreed to take your questions. So we have about 15 minutes for that. But before that, again, thank you very much for very thought-provoking and generally provoking presentation. Thank you very much. Any questions? There is one at the back.
Thank you. My question is actually for Fiona. Although it touches on the critiques that you made of the European Court, which I would agree with. But you started off by saying that we can't assume that the state is malevolent, and that the state is essentially benign and trying to its best to serve the public good. But the state really doesn't have a brain and can't have an intention that we can attribute to it. And maybe the pass that the European Court has arrived at, its exceptional deference to states, is through attributing a benign design to anti-terror legislation, rather than looking at the intention behind the legislation. Wouldn't it be better if the court and ourselves took the legislation at face value, because it's very difficult for us to know. And when internal memos and things like that are uncovered 30 years later, we find out that actually what was going on behind the state apparatus was completely different than what was assumed at the time, or the intentions that we understood at the time. So really attributing intentions to a state can be really problematic in terms of giving that additional deference to a state, rather than taking the legislation and the effects of the legislation.
Okay, thank you very much both for these thought-provoking presentations. A minor comment and a question. The minor comment is that you said that Article 3 is absolute and Article 2 is also absolute. But in the case of Article 2, we have exceptions, especially in the case of self-defense. So I'm just wondering whether we should put it in the same. Definitely, this is a very important article, right to life, but not an absolute in formalistic terms. But the question, terrorism, of course, requires prevention, and this is part of positive obligations. This is what we are discussing. But mainly the case law of the court and what we have been discussing today has to do with the question of which are the limits for state action and what the state should not do. So not to overstep its certain limits when it acts against alleged terrorists or against us in order to prevent and protect us. What about the negligence of the state? As a citizen, if I feel that I fear that I might be the victim of a terrorist attack, etc., there is no way for me to scrutinize the negligence of the state. And I think that there are two. So if the state, the question here is not about overstepping limits, but about not doing enough. And I think that there are two obstacles in that respect. The first one is the victim requirement, because in such a situation, we are all victims, so it doesn't differ any kind of application before the European Court of Human Rights from an actio popularis. And the second is the idea of national security, so that states should keep secret all the kind of action and practice they are developing in order to prevent this from happening. So should that be a question? Is there a gap in the protection in that respect? As a citizen, do I have the right to go before a court, domestic courts, or the European Court of Human Rights and say, well, I feel I'm working at an airport, for instance, in London. I feel that there are chances that there is a risk for my life and I want to know whether my state is doing enough, or I feel that my state is not doing enough to protect me. Thank you.
Maybe one more question. Before anyone? Yes. Can you use me?
Thank you very. I don't need to push a button, do I? Thank you very much for the talks. I have two questions. Is that allowed under the? Okay. Fiona, you mentioned that a state of emergency need not be temporary to be implemented. Firstly, how would you respond to some arguments that suggest the UK has been in a constant state of emergency since World War II? And secondly, in terms of another comment you made about people demanding protection and the government responding to that, it's more a question of who informs the public for their fears to be worthwhile for the government to react to. And then that comes on to media and the massive role they play in fundamentally the making of laws. And that comes on to a more philosophical idea of socially and how laws are made, but we'll not go down that road. And it's mostly about how the internet has affected the online use of media, and how the media are using online resources so people can get their information from so many different sources. And if that has, if anything, increased fears to the extent that they're more so than they were previously, because it just appears to be around more now. And if anything, if laws need to respond to online forms of media.
Okay. Do I switch it off or give it?
Would you like to go first?
That's fine. Well, if you talk about the Court of Human Rights, and also today listening to a very interesting reaction and speech on the Court of Human Rights, if you see an academic analysis, it is impressive in the way many cases are taken together and make, in a certain perspective, sense of the different cases the court has produced. And then it looks as if the court is participating in such a debate. But in reality, the court has no strategic theory in that sense. The court does not decide what cases come to the court. The court decides case by case, and it depends very much on the merits of a case, what kind of judgment follows. That's one point. It's important that the system is such that we have states who have pledged that they would secure the rights. So the basis already is a system in which there is a presumption of deference to the state in a certain way. But the system also implies that it is very well possible that there will be violations. And then it is the supervision role of the court in concrete cases to find out whether there is such a violation. And our court was criticized over the years very heavily for not granting a margin of appreciation to the states and to the domestic courts. And it is true that the last few years you see more deference from our court in relation to the domestic systems. It is very important for our court to be legitimate, not only in the eyes of the friends of the court, but also in a broader sense, not to lose the basis on which our court has to exist. So our court needs to be in dialogue with the national judiciaries. But our court needs to be critical when it comes to the essence of the rights, of course. It would make no sense if our court would only show deference to the national judiciaries and in the meantime forgot its role as a supervisor of human rights. So it should continue to take, and it does in my view, continue to take the critical role in relation to respecting human rights. If you see Article 15, the derogation clause, it is true it holds the possibility that there is a killing as a factual situation in a wartime, for instance, but in the sense that there is a right to life, I don't like to say that it is not an absolute right. I think our court considers it an absolute right, but the convention sees that in the reality of wartime situations, killings take place. Here you find the relation between, in the legal sense, between humanitarian law and human rights protection. Humanitarian law recognizes that in wartime situations, people are killed and that the necessity of this happening sometimes follows the need to protect lives. That's a very difficult relation between human rights and humanitarian law. If I turn it, you see the same difficulties in relation to relative rights. Our court stepped in the Hassan case versus the United Kingdom in saying that in order to have a good adjustment of the human rights protection with the humanitarian law, our court has to accept that in wartime situations it may be acceptable to reason in an analog way about derogating from the rights in the convention, even if no notification of an emergency situation has taken place in advance. It's very risky, but it is, from the perspective of humanitarian law and international law, also a very important. It needs to be criticized and discussed, but it is, I think, an important analysis. So that's my first reaction to some of the questions.
Thank you. Let me start with the first question. So I think by suggesting that we need not start with the assumption that the state is malevolent, and my sort of starting assumption of some kind of trust in the state, of course this reveals a lot of things about the way that I think about law. So everybody will have a different starting point. But it is true that, as Martin Loughlin has called it, this paradox of constitutionalism, at the same time we have to trust the state and be afraid of the state, right? Because that's the tension that we enter into when we create a state. And there are, so I think we can divide out, right, our ideas of why we think a state might act the way it does, and our critiques of the impacts of the things that the state does. So my starting point is that I think states will tend to be introducing laws and doing things that they are doing because they consider them to be likely to be effective in enhancing security, does not necessarily mean that I don't think we then have to look at the impacts and whether or not those measures are effective and whether or not those measures violate rights. So I don't see a tension between my sort of trust in the state, which I'm a good old neoliberal right in the state. Not everybody does. Constantine here is an anarchist, right? So he'll say you shouldn't trust, or claims to be at least, you shouldn't trust the state at all. So the starting position is particular, I concede. But the starting position not to trust the state is also particular, right? And one might be just as problematic as the other. Then in terms of, but I think you make a very interesting point about the attribution of intention to states and the impact of that on the deference that we might be willing to afford to a state's decision making. And here, in some ways, my response is very much like the response that the judge just gave. States have signed up to comply with these rights, and unless we start, even if it is a kind of a fiction, unless we start with some belief that there is an intention to actually give effect to that commitment, then the entire system will fall away, right? Because it's utterly dependent on domestic implementation and domestic effectiveness, with going to the European level absolutely being the exception rather than the rule. Okay, so we're utterly reliant on domestic compliance in order for the system to work, and thus we have to start from that point. Although I think, as I said, you make an interesting observation that means we start from a point of deference, which can, impoverish the analysis that comes later. So, but I think if you started from a separate starting point, you might also impoverish the analysis in another way. What I do think is problematic is that we very rarely ask whether or not the measures in question actually work. So we very rarely ask the effectiveness question, which I think we have to ask to balance the sort of, let's say, the license that we give to the state in the first place. The state says we're going to do this, and we say, okay, but that okay, I think, has to be contingent then on an assessment of whether or not what the state has done, A, is effective, and B, is proportionate. And that analysis, I don't believe, is fundamentally an analysis that law or courts can carry out. I think that's a sort of an operational analysis, an analysis about risk that is utterly lacking in the context of counterterrorism, and that's deeply problematic. But I'm not sure it's a job for law per se. So it's a very rambly answer to your question, but I think your question was a very good and a provocative one. In terms of the last question about the state of emergency and demanding protection. So first of all, just to be clear, I am critical of the court saying that you don't need temporariness in order to evoke Article 15. I'm Irish, in case the accent didn't give it away, and Ireland has had an almost constant legal state of emergency since the end of the Second World War. So I have empathy with that perspective, but I'm not sure that. So in this country, there hasn't been a legal state of emergency, although perhaps there has been a kind of a mentality. But just to make it clear, I'm critical of that idea of removing temporariness from what we expect to evoke in order to invoke Article 15. And your point about people demanding protection, I think, is a very interesting one. So my argument, which I won't go into in too much detail, but I published a few years ago, is that we have to understand counterterrorism laws as happening in a situation where we have a combination of top-down sort of manufacture of panic. You should be afraid, let us do things. This is your point, about the state. And bottom-up genuine fear and demand for action that people experience, so that between them we create this very potent situation where something has to be done, right? Now, you were asking about the role of the media there. So sociological literature for many years, starting with Stanley Cohen's very excellent work on moral panics, talks about the role of the media in creating these forms of panics or these forms of fear. I think that the point or the question you raise about the internet is really an important one, because when we talk about terrorist propaganda, I think it's important that we remember that propaganda in this context exists not only as a recruitment tool, but also as a terrorizing tool. And the availability and the widespread availability of so-called terrorist propaganda online now, I think, adds to people's sense of insecurity, notwithstanding its remoteness, right, because it's on a machine, and therefore adds to the demand for action. So you've identified, I think, an important point there. But laws to regulate the internet are always going to be very challenging for lots of reasons we won't get into, but I think you have identified a real problem.
Thank you very much. I would love to have another round of questions, but I'm mindful of time, and there is wine that is waiting for us, and it shouldn't wait for us too long. our speakers will stay with us for probably like half an hour. So if you have some pressing questions, you can ask them in the reception area. So again, I would like to thank our speakers for coming, and thank you very much for coming.